Hello and welcome to the Council of Engineering and Scientific Society Executives COVID-19 Legal Strategies for Association Meetings webinar. Today's presentation will be worth 1 CAE credit. To start off, we have a few reminders. All attendees are in listen-only mode. If during the presentation you have any questions or difficulties, please use the Q&A function in your menu options to alert us, or email myself, Sarah Detloff, at sdetloff@cess.org. We will be answering all questions at the end of the presentation, but please feel free to submit them as the presentation is running. All attendees can download the handouts for this webinar by selecting the handouts option in your menu items and clicking the hyperlinked PDF. We will be sending out the slides, article, and a link to the recorded webinar in the near future. Today's webinar is being recorded, and a link will be posted also to the webinar library online after the presentation. After the webinar is over, please complete the survey you received via email following the webinar. We love to receive any and all feedback. Our speaker today is Jeff Tenenbaum. Jeff is one of the nation's leading nonprofit attorneys and also is an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the Washington, D.C.-based Tenenbaum Law Group, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association Outstanding Nonprofit Lawyer of the Year Award and is one of only 5 lawyers in the prestigious U.S. Legal 500's Not-for-Profit Hall of Fame. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, and currently serves as chair of the American Bar Association's Trade and Professional Associations Subcommittee and on the ASAE Legal Advisory Council and Public Policy Committee. And with that, we will turn it over to you, Jeff.
Thank you, Sarah, and good afternoon to everyone, or good morning to those of you on the West Coast. Welcome to our webinar today for CES entitled COVID-19 Legal Strategies for Association Meetings. My name is Jeff Tenenbaum, as Sarah said, and I have been, along with my colleague Anisha Tucker, we have been spending the last 3+ weeks pretty much doing nothing but working with associations like those that you guys come from, helping them deal with all of the wide variety of meeting and event cancellation and postponement and related issues that are arising from the fallout from the COVID-19 virus. The complete, unforeseen, and devastating effects of the pandemic have caused associations to face some incredibly tough decisions right now regarding their upcoming and long-scheduled conferences and meetings in the U.S. and around the world. And even for those associations with meetings slated for the next month or two, while most do not believe that it's realistic that those events are going to be able to move forward as planned, believe it or not, the game of chicken that's being played with hotels, convention centers, meeting vendors, and event cancellation insurance carriers is a high-stakes one with potentially crippling adverse consequences for many associations. While there certainly are many venues, hotels, convention centers that are being cooperative and understanding, particularly if the association agrees to reschedule its meeting or book one or more new ones in the future, there are just as many more due to the remarkable economic pressures that they are under that are taking a harder line than we have ever seen in the past, albeit less severe crises, but never seen this hard a line taken by the hotels and convention centers in the past. With some of the most recent developments, including the classification of COVID-19 as a pandemic by the World Health Organization, President Trump and the CDC strong admonitions against gatherings of more than 10 people, and the bans or admonitions of so many states, cities, and counties around the country against the congregating of various numbers of people, associations are struggling to determine the best path forward for their conferences and meetings. The issues and considerations that are driving much of this analysis are legal in nature, contract provisions, insurance coverage, and governmental bans and advisories, to name a few of them. And it is therefore critical for associations and their advisors to understand both the basics and the nuances in this area in order to make the most informed strategic decisions that are going to best protect your association now and into the future. So with that as kind of predicate, let's move into the agenda for today. So over the next hour or so, and this, I'm going to talk for about an hour. There's a lot of information. I'm going to try to parlay some very substantive, dense, important, but complex and nuanced information that I hope I will be able to explain to you in a really clear, understandable way, because it's really important that you understand this. And then we will, I will go through as many questions as we can get through from you guys. So feel free to pose questions in that Q&A box throughout the webinar. I'm not going to be able to look at them during, but we'll try to get through as many of those after as we can. Obviously recognizing that some of the things you might be thinking about or asking about now, I hopefully will be addressing them later on in the webinar. Here's the general areas of focus for today. The focus is not on the entire impact of the virus on all association activities. It's a focus on association meetings and other events, with a very specific focus on meeting contracts and event cancellation insurance. I'm going to talk a little bit about the difference between contract law provisions and common law principles in this area. I'm going to do a deep dive into force majeure contract provisions, talk about strategies and options to attempt to cancel your meetings without penalty or reduce penalties. I'm going to talk, kind of help strategize about the pros and cons of canceling now, or waiting to cancel, or waiting to attempt to postpone. And by the way, unilateral postponement is the same as cancellation. There is no such thing. If there's postponement, it's because both parties agreed to do it. If you proceed with rescheduling the meeting for several months from now, such as the parties agreed collectively to do that, what steps can you take now to reduce risk to your attendees? Although those steps are really later, but more, what steps can you take now in your new meeting contracts to reduce the risk to you guys as the event sponsors? And then I'll close with a discussion bit of event cancellation insurance, commercial general liability insurance, and workers' comp insurance, and close with some best practices for negotiating future meeting contracts. So let's dive right in here. Force majeure. This is a clause that I'm guessing, or especially for those of you on the meeting side of the house or the legal side of the house, I'm sure you certainly know what this term means. For many other association and nonprofit executives, you probably heard the term, but really didn't have as good of an understanding of what it meant. Frankly, I've always had a good understanding what it's meant. I've never done, I do a ton of speaking presentations and webinars, and I always have for the last 25 years to association executives, but I've never spent this much time dissecting one particular paragraph of a typical meeting contract and what it means, and has so much implication for associations. So this is, it's really, really, really important. My colleague Nisha and I, as I said, we've worked with probably close to now probably 150 different associations over the last few weeks on these issues. We've reviewed way more than that many force majeure clauses. And every time we start to work with a new client or dealing with a new conference that they're trying to figure out what to do with, the first thing we do is go to the force majeure clause in the contract. It's usually in the latter part of a contract. It's usually kind of buried in the more, what a lot of people view as like the legal boilerplate portion of the contract, but I cannot tell you how important it is right now to focus on that provision. So we're going to kind of delve into this and dissect it a bit. The word force majeure is a French term that means overpowering or irresistible force. And what it essentially is, it's both a common law principle and a contract term that can work to relieve the parties from performing their contractual obligations when certain unforeseen circumstances beyond their control arise. That's the basic concept. But of course, as I said here in the first bullet point, the devil's in the details. Not all of these clauses are equal, far from it. There are great differences, some big, some small, between different force majeure provisions. Some are certainly carbon copies of others, but most have all sorts of nuanced differences that make a big difference in what they mean in this particular climate and in this particular crisis. And you'll understand what I mean as we get into that. Of course, if you are negotiating new contracts with hotels and convention centers, which many associations are doing as they work to postpone and reschedule and or book new meetings with particular venues, you can expect a difficult negotiation with the hotels. And similarly, when you are making a decision to exercise a force majeure provision, kind of, I don't know how you want to look at it. Sometimes I'm going to refer to it as kind of exercising a force majeure right, or making a force majeure cancellation or pulling the trigger on a force majeure cancellation. It all means the same thing. It basically means you believe that the conditions conditions that arise out of your force majeure provision are such that you can exercise that right to a force majeure cancellation, avoid all penalties, cancellation penalties, getting deposits back, everything else, not owe them anything, and be able to walk away from the contract. You can expect strong pushback from the hotels and convention centers when you're making a force majeure cancellation, even if your position is a strong one. As we'll get into, depending on certain language that you might have in your provisions, what we are seeing is, at least over the last few days, a bit of a trend that if you have the much less common but more favorable language in your force majeure clauses, you are likely going to have more luck getting the venue to say, we agree, it's a force majeure cancellation, you don't owe us anything. If you have the more narrow and much more common language, which I'll talk about that most of these provisions have, most, and definitely still the majority that I've seen, and we've worked with quite a few of the hotels and convention centers, are still digging their heels in unless certain conditions are met, which I'll get into. Now, there is a difference between common law force majeure principles and force majeure provisions in meeting contracts, but for purposes of today and what's going on in this crisis, the force majeure principles are not worth talking about. The focus is going to be on what is the language in your contract itself. Historically, these provisions have been some of the least negotiated provisions in hotel and convention center contracts, but right now, not the case anymore. They are front and center and critical to the analysis. And trust me, the hotel lawyers, the convention center lawyers, they're looking at these same exact thing. And then finally, on this slide, force majeure provisions in contracts are generally written to excuse complete performance. So if the clause is applicable and you can exercise it, pull the trigger on it, it's going to excuse your complete performance of all contractual obligations, including any obligation to pay cancellation penalties under that contract. They are generally not written to excuse partial performance or underperformance. And that's an important point. It doesn't mean they could not be written that way, and it's something I'm going to recommend at the end on the last slide about future meeting contracts. But it's generally the written, it's all or nothing, basically. Okay, next slide. So it goes without saying, for the larger associations that have events, say at a convention center, and then you have multiple convention hotels, we've been working with some that have 5, 10, 15, 20 different hotels in a given city. And then, of course, you have contracts with lots of different meeting vendors, again, particularly the larger groups, and even some smaller ones have some big vendors, AV vendors and others. The groups that help get all the exhibits there and set up, and the Freemans and all of those types of companies are going to have contracts with every one of these vendors, and each one likely has a force majeure provision, and every one of them may be different. And sometimes for the big association shows in a city where you're working with the CBB and you have 10 or 15 or 20 different hotels, sometimes you can work with the CBB to try to get the hotels to all agree on some core contract forms or core contract language. And in some of these, we've seen the force majeure clauses are pretty much the same from hotel to hotel, but even there, in some of those cases with the really large conferences we're working on in terms of cancellation, some of those hotels have pushed back and have some differing language. So you got to look at every single one of them differently. Now, the second bullet point, this is a really important point. You have the force majeure contract provision itself. That language, which we're going to dissect in a minute, it is what it is. It's not going to be changed. I mean, you can negotiate for future contracts, of course, but once you negotiate and that contract is signed, it is what it is. It's not going to change. You're going to need to understand it and analyze it, but you're not going to be able to change it. But what is changing on a daily basis, literally a daily basis, is how does that provision get applied to the facts at hand? So what lawyers do is they take the law, or in this case, it's not so much law, it's the contract provision, and then you apply it to a given set of facts and see how it gets analyzed. Those facts, when they are changing on a daily basis, means the outcome of how that force majeure provision gets applied to those facts, gets analyzed, what's the resulting analysis, the resulting conclusions, is going to change in some cases on a day-to-day basis, depending on how those facts are evolving. And the facts are evolving rapidly. I'm primarily talking about governmental bans, and restrictions on gatherings of certain numbers of people. Increasingly, we're starting to see and are going to see some domestic travel bans. And we're also seeing it in terms of facts changing, where in the beginning, when this crisis first started, there was fear on the part of a lot of attendees to go to conferences, but there weren't prohibitions on them attending, such as employer-instituted travel bans. That is obviously a very different story today. And it's also something else that factors into the analysis to the extent you have, for instance, a very large number of your would-be attendees who are subject to institutional, like employer-based travel bans. That is another relevant factor in the analysis. This third bullet point I'm going to talk about later at the end. But the fourth bullet point, this is really important. So now we're just focused on the provision itself. We're going to do a little deeper dive because it's really important you understand this. I view force majeure provisions, most of them, as having two parts, and it's like a two-part test. So you can think of it like this: both parts of the test have to be satisfied in order for you to successfully exercise a force majeure cancellation without penalty. Now let's dive into what that means. So this is not the only or the best, but it is a model force majeure contract provision from the association's perspective. From the hotel's perspective, convention center's perspective, no, they're not going to like a provision like this. They're going to like perhaps some version of it. And in fact, if we could, frankly, you knock out probably the last sentence and you knock out two key words or three key words, most hotels can probably live with this. But this is what I mean. It has such a, the words really matter. Every detail in here matters. And I'll explain to you what I mean. And don't focus on that last sentence right now. That's kind of an ancillary point. Right now, if you look at the beginning part of this provision, this is how most force majeure provisions start out. They have a list of what are qualifying events. Let's call them, I like to call them force majeure events, because I'm trying to distinguish from like your overall event, like your meeting and conference. But these are events that could take place that will trigger this provision, saying if one of these things occurs, then all of a sudden this provision is in play. Doesn't mean how it's necessarily going to play out and how it's going to be applied, but it's in play. It's kind of triggered. And almost every force majeure provision I've ever seen, probably everyone I've ever seen, starts out with things like act of God. That's always first. War, government regulation, disasters. Those are kind of the big common ones. And then, they really vary in terms of other things. Now, I have a fairly broad list here. As you can see, I highlighted and emphasized disease, which is somewhat common. Believe it or not, it's definitely not been in the majority of contracts that we've reviewed, and we've reviewed hundreds in the last few weeks. It is not in the majority of those. I don't want to say what percentage, it's hard to say, and sometimes it'll refer to epidemic or infectious disease or communicable disease, things like that. But it's here, I try to use the words that are going to be the broadest, because from the association perspective, you want this provision to be as broad as possible. You want it to capture as many different potential force majeure events as possible. And so you want that list to be as long as possible. And of course, you want it to include disease. But this is really important. Don't panic if you're looking at your hotel convention center contracts right now, because you got a meeting coming up in June and or even late May or July, and you're just not confident that we're going to be through this crisis by then, and you're already thinking about potential force majeure cancellation, and you're looking at it and you said, oh shoot, it doesn't make any reference to disease or anything like that. Don't worry, so long as you have a catch-all phrase. In this particular version, if you look about a third of the way down, it refers to or other similar cause beyond the control of the parties. Sometimes it's also worded as, the list shall include, including but not limited to. Either way, you want to have that sort of catch-all phrase because it's critically important, so that even if your event, the qualifying force majeure event, is not in that list, you can refer to that catch-all phrase and say, okay, but it's other similar things. And there are always going to be things that arise, unforeseen events that arise in the future that we can't possibly think of and that don't fit neatly into one of those buckets of defined events. So you always want to have a catch-all phrase. Most force majeure provisions that I reviewed do have some kind of catch-all phrase. I reviewed one yesterday that literally had those first four things: acts of God, war, government regulation, and disaster, and nothing else, and no catch-all phrase. And thankfully for the particular association, it was a small meeting, kind of more like akin to like a board meeting. So not nearly as much in terms of financial penalties involved, but we had to tell them, in terms of the contract itself, I don't see any way that we're going to be able to gin up an argument that the force majeure provision is going to apply. It was just way too narrow. So that's the first part. But like I said, usually there's a catch-all phrase. So usually the first part of the test, you're going to be fine on. It's the second part of the test where we've been really focusing much of our analysis and much of our negotiations with the hotels and convention centers. And that second part of the test is, what is the effect that triggering event has on your ability to perform your obligations under the agreement? The hotel's obligations too, but on their part. But usually, it's the association trying to get out of its obligations, not the hotel trying to get out of its obligations. So, it's really, what effect does that triggering event have on your association's ability to perform under the agreement? Here, in this particular model provision, it talks about the event making it inadvisable, illegal, impossible, or commercially impractical to hold the event. This is the kind of language that you as an association want to have in there. It's broad, it's flexible, particularly the two bookends there, inadvisable or commercially impractical, are the two most important terms. You want to look for words like inadvisable or impractical, or come up with your other synonyms for those words. Anything else that's analogous to that will work, but you want to have something broad that's not just the two in the middle, illegal or impossible. Unfortunately, about 85%, maybe 80% at least, of all of the hotel and convention center contracts that my colleague and I have reviewed in the last few weeks have had simply the illegal or impossible standard, and they've not had more broad, flexible language. And I can tell you, seeing how this plays out, we've been down this path so many times. Every day we go through this, and the ones that are exercising force majeure termination for meetings and conferences that are coming up fairly soon and that have the inadvisable or commercially impractical language, in almost every case, maybe not in the beginning, a week or a week and a half ago, but now most of those properties, the venues, are saying, okay, we agree, it's a force majeure cancellation and you can walk away without any penalties. On the other hand, the ones that have an illegal or impossible standard, the hotels and convention centers are taking a much, much harder line. And I'll get into a few examples here in a minute, which are probably going to surprise you, and even things that are going on as recently as yesterday and today. And so that's kind of the two-part test. And you want, obviously, to be looking for inadvisable, impractical, or similar language. If not, then what you're stuck with is illegal or impossible. And so you have to be able to show that it is illegal or impossible for you to hold the meeting in order for you to get out without penalty. I'm going to spend the next few minutes talking about that scenario where it's the standard for force majeure is illegal or impossible, because that's the vast majority of what's out there. And so in those situations, almost all of the hotels and convention centers that we've seen have taken the position that they will not allow a force majeure cancellation for a clause that says illegal or impossible unless there is a governmental ban in place that unambiguously legally prohibits you from holding your particular meeting. Now, you might look around and say, hey, oh, that's great. I mean, not great that we have these bans, but great from a contract negotiation perspective, or being able to exit a contract obligation, because we're seeing more and more states and cities and counties instituting these bans on gatherings. They vary in terms of the number of people involved. They certainly vary in terms of the temporal element, the date, the timing of when these bans are in force. Some of these bans, like I'm in DC, the neighboring state of Maryland, the governor there actually imposed a mandatory ban on gatherings of more than 10 people yesterday. Prior to that, I think it was a mandatory ban of gatherings of more than 250 people, or it might have been reduced to 50, I can't recall. But either way, it's a mandatory ban, and obviously applies to things like association conferences. But the important element I'm trying to highlight there is that ban is in place indefinitely for as long as the Maryland state of emergency is in place. Now, does that mean you can interpret that to enable you to use that to cancel a contract that you have for a meeting scheduled in Maryland in November of this year? I've advised some clients that I don't think that's a reasonable position to take. I think if push came to shove and a court had to interpret that, it would say, look, it's reasonable to assume that this ban is going to be in place for the next 2, 3, maybe 4 months, but to just assume it's going to be in place all the way 6 months, 8 months or more in place is not a reasonable position to take. The timing element is critical. In DC, we have a ban on gatherings of over 250 people right now. Again, all of this is changing on an almost daily basis. That ban, under the emergency regulations that DC Mayor Bowser issued, is in place right now only until March 31st. Now, the emergency regulations say that she has the right to extend that. And obviously, if she does, she will announce that and announce the terms of the extension. Everyone assumes it will be extended. We just don't know for how long and whether there'll be other changes made to the terms of that ban. But the timing element is critical. We have a few clients or 2 clients that have conferences coming up in DC in April. Right now, that ban does not apply to conferences in April. So if you wanted to rely on that ban to say it's illegal or impossible for us to hold the meeting in April, can almost guarantee you, because we're seeing it almost every day, the hotels and convention centers will push back and say, nope, sorry. And this is because you can think of it like this. The moment you give your written cancellation notice to the hotels and our convention center, it locks in the facts that exist at that particular date. So whatever bans might be in place, doesn't matter if it changes the next day, they are taking a position that whatever was in place at the moment we got your cancellation notice, that's what's going to apply. So the timing issue is, I think, the most critical. Let me move on to the next slide because I think I have more on this. Well, this is pretty much just a restatement that the hotels are going to push for, when you're doing new negotiations, for impossible or illegal as the standard, much narrower, much tougher to meet, whereas associations and event planners want to push for broader impracticability and inadvisability or similar language. Precise language is really important, and this last point, this basically, actually, I'll get into that a little bit later because I don't want to distract from the current discussion. I probably need to reorder that in the slide deck here. But this is really where I'm getting into now, and I want to really spend some time focusing strategies and options. This is where my colleague and I are spending most of our time advising associations on these issues. Yes, we first have to get a handle on what do the different contracts say. How do they relate to each other? Are there other bases for cancellation beyond force majeure that might apply? All of that sort of stuff. We are also looking, of course, at event cancellation insurance policies, because that's going to factor into the analysis as well, as the second bullet point says. I'll talk about that later in the webinar. But after we do that, then we say, okay, remember I told you it's all about how the force majeure provision applies to the facts that exist on any given day. So let's get back to my DC example. And this is, frankly, what we're telling a number of clients, and they're having a tough time with it because, as you not only can imagine, most of you are probably hearing it, at least if you have conferences coming up anytime in the next few months that you have not canceled yet, you are under enormous pressure from your members and your registrants and would-be attendees to cancel that event. We're hearing it across the board. We're hearing every day, look, our board and our executive committee or whatnot, they just can't, they're not going to last any longer. We've got to pull the trigger. We have to cancel. And in some situations, after analyzing all this, I am telling them, in fact, I had to get on the call with an executive committee of a client yesterday to convince them, hold off. Things are going to change almost certainly in the next few days in this particular jurisdiction. Once they do, we're going to be able to immediately pull the trigger. We'll have the cancellation notice all ready to go. We'll have the communication to the members all ready to go. But if you pull the trigger too soon, what we've seen is that the hotels and the convention centers, particularly the hotels, are literally sending invoices the next day for the full amount of the cancellation penalties. And if you paid any deposits, they're keeping the deposit, which they have the right to do, apply it to the cancellation penalties, and then sending you a bill for the rest and denying force majeure cancellation. And the hotels lawyers from all the big chains are very, very much on top of this. They understand exactly this analysis, and they're playing that same game of chicken. And if you pull the trigger too soon before you have a really strong case for force majeure cancellation, you're going to have a battle on your hands. I'm not saying you won't be able to negotiate your way out of it, negotiate for some future meetings with them in exchange for reducing or eliminating, the cancellation penalties, but you're going to have a battle on your hands, and you want to avoid having that battle. What you want is to get, the emails from the from the director of sales or the GM, however, it's usually the sales director saying, we've accepted your force majeure cancellation. You don't owe us anything, but we hope you'll consider rebooking with us in the future. I'll tell you, in these really horrible, difficult times, to me, as an outside lawyer to associations, that's been the most gratifying part of this job. There's been a gratifying part of the last few weeks, is getting those force majeure cancellations accepted by the hotels and the convention centers. But it's not by accident. It's not because they're just trying to be nice. I mean, they are under enormous economic pressure. Their industry is taking a massive, massive hit, and they have to try to recover every revenue that they can. And these big meetings and these cancellation penalties, and that we're talking hundreds of thousands of dollars, we're talking some that are 7 figures. These are huge, and you can have cancellation penalties for every separate contract as well. Some of the big AV companies have big cancellation penalties, all of the rest. And so these are really big dollars at stake. The timing matters, the detail matters. I saw one yesterday. It's actually not a client of mine, but a client forwarded on to me. Association having an event that was scheduled in DC at a hotel, not going to mention names, of course, in March. The mayor's ban was in place for 250 or more people for any mass gatherings, and the ban and the emergency regulations talks about conference rooms and banquet halls and things like that for all the examples of mass gatherings. The association did a force majeure cancellation, saying it had the standard illegal or impossible. They said because of this ban, it was impossible for us to hold the meeting in DC. And guess what they got back? They got back an email from the hotel with copies to the corporate lawyers from the hotel chain saying, sorry, this ban does not apply to us. We are not accepting your force majeure cancellation, and you owe us the full amount of cancellation penalties. And the reason they did that is the definition of mass gathering in the DC ban has an exception for, if I recall, I should have it in front of me, but residential buildings, office buildings, and hotels. And clearly, well, I shouldn't say clearly, we don't know the true intent behind this, but to me, I read it initially as, of course, they mean, the hotel sleeping rooms. You can have more than 250 people in a hotel as long as they're separated in separate rooms. You just can't have them all in the meeting facilities and whatnot. Well, no, one of the biggest hotel chains in the world has taken the position that this ban does not apply to them because of the way that those emergency regulations are written. And so now we're obviously using that information to help advise other clients who may be thinking about exercising their force majeure cancellation rights in connection with a hotel in DC. You have to look, I'm using it as an example, where you have to look at all of these things. And despite the fact, you're probably saying, this is crazy. Yesterday, State Department, banned all international outgoing and incoming travel throughout the whole country, level 4 restriction. We saw the California governor, first the LA mayor and then the California governor, essentially issue a statewide lockdown. Almost a full quarantine of the entire population of the largest state in the country. We hear the president and the CDC and others, and the federal government strongly advising against any gatherings of over 10 people. We're seeing countless, dozens or hundreds of states and cities and counties across the country instituting all sort of bans. Yet in the last 2 days, we got clients of mine got letters. One was from one of the big hotel chains, one, a property affiliated with a big hotel chain. Another was from a property affiliated with a separate, unrelated, very large hotel chain, both having this exact same language. I don't know how they compared notes or where they got it from, but let me just read this to you, just to give you a sense of this game of chicken is really serious, and associations need to be really smart, sophisticated and strategic about these decisions, because the hotels most definitely are. This is a quote from the letter. While there has been a great deal of recent publicity regarding coronavirus, currently this situation is essentially no different than other health advisories issued by organizations like the CDC or the WHO. These organizations report on outbreaks of various types of influenza, West Nile virus, and even measles, all of which occur in the US. We will continue to closely monitor coronavirus updates, and will respond based on the advice of governments, public health authorities, etc. However, generalized risk of communicable disease is a fact of life, and therefore is not an unanticipated circumstance that will entitle the party to invoke force majeure under current circumstances. So they are saying, even despite all of this, It's not impossible for you to hold the event, so you owe us, and this was followed with a bill the next day for the full amount of the cancellation penalty, several $100,000. This is real. When I say that there's this game of chicken being played, I'm not exaggerating it. And this same letter was received by 2 different clients of ours in the last 2 days. This isn't from 2 weeks ago. So you need to be smart in how you determine your game plan, your strategy. And as we've told a number of clients right now, especially looking at ones that are in like late May and June, and some of these bans don't extend that far out, these governmental bans. If you have illegal or impossible language in your force majeure clause, our basic advice is wait. We know you're under a lot of pressure, but you got to wait. Don't pull the trigger too soon. If you wait, you're going to thank us later, as many of our clients have. And if you pull the trigger too soon, I'm not saying you'll absolutely be stuck with a huge cancellation penalty bill, but there's a much greater chance you are, and you're definitely going to spend a lot of time, resources, and headaches trying to negotiate your way out of it. A few other points here. Even if you do lack a strong legal position, for instance, like in who knows if it's changed in the last 24 hours, but like in Philadelphia, my hometown, the ban on mass gatherings is still set at 1,000 people or more. I don't know why that hasn't been reduced. It doesn't make any sense to me, but it is 1,000 people or more. And if you have a smaller meeting that only gets on average 250 people, you're going to have you're not going to be able to say that ban applies. You have to also look at, we have a kind of an ongoing spreadsheet that we update on all of these various state and local bans. You have to look at the state of Pennsylvania to see where their ban is and what it applies. But say you're in a state and a city, a meeting where you don't have a strong legal position, then kind of the old tried and true way of negotiating your way out of cancellation penalties was to either reschedule the meeting for some future date and/or contract with the venue for future meetings. That can sometimes help with negotiating your way out of penalties, or at least reducing them. Some of the venues are saying, okay, we're going to charge you the full amount of cancellation fees. In the beginning, they were saying, we'll let you apply 25% of that total to the future meeting you book with us if you do it within 12 months. Talked to one client's general counsel yesterday, and he told me that they got the property to agree to apply 70% of the cancellation fee to a future meeting if they book it in the next 12 months. He and I thought that was a good outcome considering the circumstances and where they had initially dug their heels in. But every one of these is different. And then the last consideration here, and it is a consideration like in any negotiation over things like this, is who's got the money. Do they have a big deposit of yours already? Because if they do, if they disagree with your force majeure cancellation, they're going to keep it. And they're going to say, we disagree, we're going to keep it. And essentially what they're saying is if you disagree, come after us, come sue us, which, you're often not going to do unless the amount is really significant. If they don't have any deposit money of yours, they don't have much, and say they don't have a credit card on file they could charge, then they would have to come after you for the cancellation penalties. And I'm not at all suggesting that if you legitimately owe them the cancellation penalties, you shouldn't pay it or shouldn't be obligated to pay it. And they can make your life difficult. They can really do some damage to your corporate credit rating and things like that. They can send it to a collection agency, all of that stuff. And I'm not suggesting you go down that path. What I'm suggesting is you factor that into your game planning and your strategy and analysis, because it does have an effect on decision making, both on your part and the part of the venue. All right, so this is kind of more essentially a continuation of this same discussion. A little bit of a recap here. The terms of the force majeure provision are set, but the facts on the ground change every day. You have to analyze it every day. We have some clients that email or call us every few days. They're like, oh, we saw this development. We saw this announcement from the president or the coronavirus task force. We saw this. Does this change things now? Can we cancel now? We saw that the governor or the mayor of this particular state or city, changed their ban. Does this apply to us now? We have one. There's a property that a lot of associations have meetings at, the Gaylord Texan, which is in Grapevine, Texas. And our client had reached out and said, oh, I saw that Dallas and Dallas County, I can't remember if it's the city of Dallas or Dallas County, but either way, had instituted a new lower ban on mass gatherings. And they said, oh, this should cover us. I think it was 50 people or something. And we looked at it and we said, unfortunately, the Gaylord Texan is in Grapevine, which is in Tarrant County, not in Dallas County or Dallas City proper. Therefore, the ban in Dallas has no impact on the ban in Tarrant County. And at least at that time, it was a higher, I don't remember if there was no ban at all, because some of these states and cities still have recommendations. They don't have bans. And it's something you have to really carefully look at, because at the federal level, right now, there is no ban on gatherings of any size. There are strong admonitions, warnings, pleading with people, but the federal government has made a deliberate decision. Some people don't agree with it, but a deliberate decision to not institute any mandated bans, and they've decided to leave it up to states and cities and counties to decide. And many states and cities and counties have still decided to not institute formal bans, but to just have recommendations and admonitions. You need to look carefully, because what we're seeing, the hotel lawyers are very sophisticated about this. And if it's just a recommendation or an admonition or a warning or a recommendation, they're not going to give it any credence if you have an impossible or illegal standard in your force majeure provision. So as such, there are definitely instances when waiting to pull that trigger, waiting to lock those favorable facts into place are going to make a difference. And one other thing to talk about here, I've focused heavily on governmental bans compared to warnings and admonitions, because it's most of the hotels and convention centers have taken the position, as I said, unless there's a legal ban in place that unambiguously applies to your meeting in that city on those particular dates in the way that the ban is written, without exceptions. That when I say unambiguously, that's what I mean. Unless that's the case, we're not going to let you out under a force majeure cancellation for an illegal or impossible standard. That being said, I don't particularly agree that that's the only way to meet the impossibility standard. And probably I can come up with a lot of different examples, but the one most relevant one is the one where a majority or even a vast majority of your attendees, your speakers, your exhibitors are literally banned from attending because their own employers, their own institutions have banned them from travel. And we see that a lot with large companies. We see it a lot in higher ed. We see it a lot in healthcare. And I know this particular group, assess, is going to have a lot in those latter two categories. And as a result, actually, let me move on, because I think I have another slide on this. As a result, in those particular, no, I don't. In those particular categories, it may be very worthwhile, and we've advised a number of clients of ours, to poll your members. This is for like a meeting that's upcoming, say, in 6 weeks or 2 months, and you're not confident taking the existing governmental ban because it just doesn't apply to your dates yet, or you're not sure if it even applies based on the number of attendees. You want to have as much evidence as possible, kind of a belt and suspenders approach, to be able to support the impossibility argument. So if you think the vast majority of your attendees not only are scared to attend or are following the advice of the federal government or whatnot, which of course they should be doing anyway, but like I said, the hotels are looking for impossibility, not is it a good idea or a bad idea, is it impossible or illegal for them to attend. If you can show it's impossible for them to attend and therefore impossible for you to hold the conference because the vast majority of the folks are not able because their own employer instituted travel bans to attend, that's relevant, but the hotels and convention centers are likely not going to take your word for it. They're going to look for proof. And so if you can gather that sort of proof now, that can be very helpful to you. As I'll talk about later, the same goes when you're filing a claim with your event cancellation insurance, if you have any. It's the same sort of standard that you're going to have. It's a little bit different, little apples and oranges, but it's effectively the same. And you want to have as much evidence as possible to support that. And then this is a last point I want to make on this part of the program, and that is the cancellation notice itself. Cancellation notice that you send to the hotels, the convention centers, your vendors. Critically important. You want to make it as substantive and specific as possible. You want to put your best case forward. It's almost certainly going to go to the venue's lawyers to take a look at. They're going to be looking at all these same things that I'm talking to you about here. And you want to put all of that in there. This should not be a one-paragraph cancellation notice. It should say all of the reasons why you want to cite the relevant language from your force majeure clause. And then you want to cite all of the relevant facts and legal arguments why you believe it is impossible or illegal for you to hold your meeting. Of course, you're going to cite any directly applicable government bans, but you should also cite all of this other, strong admonitions from the federal government and elsewhere, the CDC, about what you can and should not do, particularly what you should not do. And then you also want to cite things like institutional travel bans and whatnot that your attendees may be subject to. All of that should be put in your letter. And same thing goes, of course, with I'm going to have to work later today on a insurance claim submission for one of our clients. And same thing there, you want to back it up, perhaps even more so, with as much evidence as possible to make that same case. Really, really important. And then finally, we're spending a lot of time also reviewing and editing member communications, like to registrants, attendees. As soon as the cancellation goes out, the notice goes out to the hotels and convention centers and vendors, you're probably following it with a communication to your registrants and all of your members, telling them what you did. You want to make sure that what you say in those communications matches up to what you say in the communications to the hotels and convention centers, because later if there's a dispute and the hotel or convention center comes after you and says, no, we disagreed, we didn't feel it was impossible, might not have been a smart idea to hold it, but it wasn't illegal or impossible, and that was the standard that you had agreed to in the clause, and they end up suing you, or there's a mandatory arbitration clause, or whatever the case is, all of that stuff is going to be relevant. And if you have communications to your members, even to your board, we've been reviewing a lot of board communications, that are inconsistent with the reasons that you gave to the hotel, that's a problem, and you don't want to be in that particular boat. So now, whether you are using a renegotiation of your current upcoming meeting in order to avoid cancellation penalties, or maybe you've gotten out of the cancellation penalties pursuant to force majeure. And what I've told clients is, if you have a strong case for force majeure, and we believe you have a strong case, pull the trigger, exercise it, get out of your obligations. Hopefully the venue agrees. And then if you decide you want to renegotiate that meeting, or maybe a lesser size version of it, for say October, November, December of this year, and there's a lot that seem to be focused on October and November, with a lot of some people believing that the crisis will have subsided enough by then to hold in-person meetings, others not sure. But say you decide to do that, right? Either to negotiate your way out of the penalties, or you've gotten your way out of the penalties, and you're just going to try to see if you can negotiate it. You're going to have maximum leverage if you're not subject to potential penalties from the old contract. If you're free and clear, that's ideally the negotiation posture you want to be in. But when you negotiate that new contract, and especially if you have more leverage, like you're free and clear from the old one, what you want to do, and I was literally just on the phone with a client before I got on this webinar, helping, it's the director of meetings for a particular association, helping her with the language, because she's about to jump on the call with the sales rep from the hotel. They're renegotiating their meeting for, I think it was November of this year, and I'm working with her to get language in there so that if it turns out that the virus has not subsided to the extent we thought by the fall, or perhaps it has, but there's just so many folks, understandably, that are just going to be reluctant to travel until we have a vaccine or some other kind of clear end to this crisis, that are going to be reluctant to get on a plane, reluctant to go to mass gatherings, things like that. And that is going to be the case. That's going to be the case no matter what. Whatever events that you were going to have in the old world order that you're going to have this fall, without question, are going to have less attendees than you would have otherwise had, unless you're just unbelievably lucky. That's just going to be the reality. So what you want to do is make sure you're not in the same situation 6 months from now. So what do you want to have? Of course, you want to have really favorable force majeure language that has the inadvisable or impractical standard, so that if you do need to cancel for those reasons, because things are really still not safe, or other reasons, you want to be able to get out of it. So far, most of the hotels that we've been working with on this have been pretty flexible on that new force majeure language, because they really need the business and they want to lock in business now as much as they can. But the other thing, use your leverage wisely, is if you can negotiate away the attrition penalties. So attrition penalties are the penalties that you have to pay when you don't meet your minimum guarantees for sleeping rooms and sleeping room revenue and food and beverage revenue. And as all of you know who do this sort of stuff, typically they're two separate things. You generally have like minimum amounts that you have a right, typically. So if you negotiated your contract, a year or 2, 3 years out, you have certain time periods during which you can reduce those guarantees by certain amounts, certain percentages, usually down to some floor. And then once you pass a certain point in time and you get closer to the mean, you can't reduce it anymore. And essentially, if you don't meet 100% of it, or 90% of it, or sometimes 80% of that minimum, then you're stuck with those attrition penalties. Use this opportunity to either try to negotiate those penalties out of the contract altogether. You might be able to do that if you have a lot of leverage. If not, then B, at least get the minimums very low or low enough that it's safe for you, you're comfortable that even if you had a 50% drop off, you're not going to be hit with big attrition penalties, or have the ability to reduce those penalties down to a lower amount, as you get closer to it and see how things play out, maybe closer than you would typically have in terms of the time period. And then that percentage of, what you have to meet in your guarantee in order to avoid penalties, maybe instead of 80%, you push it down to 70% or 60%, something like that. Again, every situation is going to be different in terms of what you're able to negotiate, but these are the kind of things you want to focus on so that you're not hit with big financial penalties 6 months from now. And then, of course, I'm not going to talk about this now. This will probably be a webinar for 3-4 months from now, hopefully, is okay. Now we're back in the meetings business. Now, we have the crisis is generally under control. People are starting to plan their future meetings. There's still going to be some risk out there. So what do you as an association, as a meeting planner, what do you need to do to mitigate your association's risk from holding the meeting? The idea is you don't want someone to be able to, an attendee who goes to your meeting and contracts the virus, for instance, or other harm comes to them, say, hey, you were negligent, A, in holding the meeting so soon after this crisis was at its peak, and B, you didn't take appropriate steps and or make the hotel or venue or convention center take appropriate steps to keep everyone safe. Therefore, you were negligent, therefore you should be liable for all the harm that I suffered, medical bills, lost wages, etc., pain and suffering. That's the kind of liability you're going to very much want to avoid. And so there are going to be a lot of kind of due diligence steps that you're going to have to take when we get back into the business of in-person meeting in order to mitigate your liability risk there. Okay. Now, last kind of primary topic here, event insurance. Let's first talk about event cancellation insurance. So even in that best case scenario where you have a broad force majeure clause, inadvisable, impractical, you're successfully able to exercise it. The hotels and our convention centers agree, you don't owe us anything. We hope you'll come back to us in the future. That's great that you've avoided all your cancellation penalties, but you're still out your lost profits. Whatever profit you would have earned, and most associations do make profits from most of their meetings, some very significant ones. Some, the biggest meeting is the annual one is often a significant part of your overall profits for the year. You're out all of that. But what if you have event cancellation insurance that applies? Well, if it does, all of the policies will make you whole for your lost profits that you would have otherwise earned. There's certain limitations and other things, but generally speaking, that's the idea. Event cancellation insurance will cover your losses and your lost profits for meetings that get canceled, that get postponed, and also if you move ahead with a meeting but you have reduced attendance and thus reduced profits, it'll make you whole for those as well. Now that's if you have insurance for that event and if it applies. So now let's talk about if it applies. So first off, going forward now, just talking to a client earlier today, they have a meeting coming up in, it's June or July, I can't remember. They typically, and this seems to be common, I never really knew this until now, the timing of when a lot of associations will secure their event cancellation coverage for the events, those that are in the habit of doing it. And they often don't do it until about 6 months out. Some have done it, a year out, but it seems more common that 6 or 9 months tends to be the case. And so for a meeting in July, unfortunately, this particular association did not bind their binding, meaning getting it issued, their event cancellation policy before this crisis broke out. At this point now, all of the event cancellation insurance carriers exclude coverage for coronavirus from their policies. And I mean, it's understandable in that event cancellation insurance is designed to cover unforeseen events that occur. This is no longer an unforeseen event, so it's not surprising that it is excluded and will be for some foreseeable time in the future. But for policies that were issued prior to this year, that's definitely not necessarily the case. There were no coronavirus exclusions. So let me just talk a little bit about the specifics. So the first two policies here, the Showstoppers one where Aon is the broker. Some of you are familiar with that because that's the one that's endorsed by ASAE. Expo Plus, probably the other biggest, the one that we see the most. Mercer is the broker. And the one we see the third most is HCC, Houston Casualty Company. The first two are very similar. In fact, they really kind of copy each other. The provisions are almost identical. between the two. And both of those, Showstoppers and Expo Plus, since 2003, when the SARS virus broke out, it was a big issue. They have excluded communicable disease from their core policy. So the base policy, if you can think of it like a core contract and then like amendments to the contract or something. The core contract since '03 excludes any claims that arise from communicable disease. So any cancellation or whatnot that derives because of some communicable disease, including coronavirus, is excluded from those policies. However, you have the right and option since then to purchase an endorsement, which is like an amendment to the policy. You have to pay extra for it, usually about 20% of the total premium. It varies, but that's what we've seen, that you can buy back that coverage. Unfortunately, we've heard from at least 24 different associations that said they never knew they had the option to purchase that endorsement from the broker, which makes no sense to me, frankly, from an economic perspective, because the broker would make more money if the premiums are higher, because they get paid as a percentage of premiums. But for whatever reason, many associations either were not told about the option to purchase the endorsement, or just never heard it, or didn't remember it, or whatever the case was, or didn't read it. But for whatever reason, there are many associations that did not purchase that endorsement, and therefore they do not have coverage now under their policy. It's really sad and unfortunate because there's huge dollars at stake. The ones who did purchase the endorsement, and we have a lot of clients who did, they should be, and I can't say for sure because I've yet to see a claim successfully processed through the insurance carriers and finalized. Some of them are going through the claim adjustment process right now, and the adjusters are asking for a lot of detailed information. But I've yet to see one where the outcome is going to be. But they should be in pretty good shape, particularly if they're in a jurisdiction, the meeting was in a jurisdiction that's subject to a governmental ban. Because even if you purchase that endorsement, those endorsements for those two policies say, however, this will not apply if it's simply the fear of attendance that is driving your cancellation. But if it's truly a ban from a government, or maybe from employer travel bans or whatnot, they should be in good shape to be able to get coverage. And this is something we're going to end up doing battle over, I'm sure, with some of the insurance carriers down the road. And finally, for the HCC policy, for whatever reason, I'm guessing it was for competitive reasons, to try to be a more favorable competitive alternative to Showstoppers and Expo Plus. They had never until now instituted any exclusion for communicable diseases. And the basic way these policies work is that unless it's excluded, then it's probably going to be covered. These are broad insuring clauses. And that's the way that most liability insurance works. Is that if unless it's expressly excluded, it's likely going to be included. That's at least the default rule, if it fits within that broad insuring clause. However, for this particular policy, they have an unusually narrow definition of cancellation that the other policies don't have, where they refer to cancellation as the association being physically or legally unable to hold the event. If that sounds familiar, it strikes me as kind of similar to the illegal or impossible standard in force majeure clauses. But again, if a government ban is state or local governmental ban is unambiguously applicable to your meeting at that time for that number of attendees, I think you're going to be in pretty good shape. And we'll see. We're working with a few clients that have claims that either have been or shortly will be submitted to HCC. And these issues I pretty much already talked about. So I already covered those in that second slide. So two more quick issues. Commercial general liability insurance. This is kind of think ahead, fast forward several months, 6 months, whenever it is, when you're going to start to hopefully hold your in-person meetings again. I talked earlier about the liability risks of holding those meetings, and what if, God forbid, something bad happens, someone contracts the virus at your meeting, and they say you were negligent in your precautions and you didn't do due diligence with the hotel and everything else. And by the way, due diligence with hotels is going to be critical. It's going to be critical. You're going to have your own, there'll be models, I'm sure, that'll be shared amongst you guys and everyone else about, here's the kind of checklist you have to make sure that the hotel is going through, for health and safety reasons before you can even consider having your event there. And you're going to have to make sure they actually do all of those things. I've actually seen one association use that checklist mechanism now for a hotel that was being really obstinate and just not giving it all. And they said, okay, well, we're considering having our meeting in 3 weeks, but we need to know that our attendees are going to be safe. So here's a long list of all the things that we're going to expect you to do if you want to fulfill your obligations under the contract to have a safe, healthy environment for our attendees. Sure enough, the hotel conceded 2 days later and said, you're off the hook, no cancellation penalties, you're free to go. It's a tactic that you should consider, and that we're actually going to start employing for those cases where we can't rely on the governmental ban, at least not yet, but the client is desperate to cancel. You got to use as many tools in the toolbox as you can. But my point on this slide is that if you do move ahead with the event, you've done your due diligence, everything else, and you still get sued, you can never stop someone from suing you. Your commercial general liability insurance does not contain any exclusions for communicable diseases. All these policies are the same, they're standardized, and at least for now, there's no disease exclusion. So at least for legal fees to defend you, they have these policies of duty to defend policies. They should have an obligation to defend the lawsuit against the association. Whether they're going to, if you ended up losing the suit and had to pay a judgment to an attendee who claims they contracted the virus at your event, the insurance carrier is likely going to push back. And that's what I talked to a few brokers about this, and they agreed. It's probably going to be tough to get the carrier to agree to pay the ultimate claim if there was one, but you should be able to get them to mount a defense. And if there's a modest settlement to make the case go away, they'll likely pay for that as well. And then finally, workers' compensation insurance. This applies to your employees. So once we're all in work from home mode right now, once that changes, hopefully it changes, hopefully sooner rather than later, and your employees are out there, you guys and other employees of your organizations are out there, and there's some risks to contracting the virus or whatnot. If there are costs that accrue from that, and liabilities particularly that accrue from that, your workers' compensation insurance should apply to cover your organization in that particular case, because there are no exclusions for communicable disease in workers' comp policies. There could, of course, be other unrelated exclusions that apply, but there's no disease-related exclusion. And then finally, best practices for negotiating future meeting contracts. Of course, this goes without saying, you guys know now more about force majeure than you ever thought possible. Focus heavily on the details and the nuances of the force majeure provision in your meeting contracts. Try to get it as broad as possible, both on the front end, the first part of the test, and the back end, the back part of the test. And I should say that there are some clauses that we've reviewed that only have the first part of the test, and the second part of the test is just not there. Whether that was intentional, unintentional, I think in most cases it was unintentional. That is a very favorable situation for an association. It's very unfavorable for a hotel or convention center. But I've actually seen some hotel contracts that have the long list of triggering events, and then there's usually a catch-all provision. But then there's nothing in the back end. It just says if there's a triggering event, then force majeure applies. That's golden. I mean, that's the perfect scenario. If you fall into that particular bucket, you should be very fortunate. And in that particular case, unless your meeting is really, really far out, I think you're probably going to be in a safe place to rely on that. But I'll caution you, none of these things are as simple and straightforward as you want. Don't make any decisions based just on what you've learned here today, or what you've been reading in the press, or what you've heard from other colleagues. Make sure you do a deep dive, a relatively deep dive on any of this stuff before you make any concrete decisions. This is too much at stake. The negotiations over force majeure provisions, I think, are going to be really difficult and hotly contested in meeting contracts for the foreseeable future. This third bullet point, either tie the force majeure provision into the attrition clause so that if there's a force majeure event, but you decide to go ahead with the meeting anyway, and in that model contract, I didn't focus on it, the model provision earlier in the deck, which you'll see. The last sentence basically says, if there's a force majeure event and we decide to go ahead with the meeting anyway, then you agree to waive any attrition penalties, or at least reduce them. Something to keep in mind. Alternatively, just try to negotiate the attrition penalties out of the contract altogether, or try to negotiate them low enough that it's not going to do tremendous financial harm if you have really low attendance. This has to do with this frustration of purpose doctrine, which I really didn't want to get into because it's really not terribly relevant right now. But I'll just say that for those of you who have worked with us or do work with us, you're going to see in the cancellation notices that we put together, we always put one sentence in there that refers to the frustration of purpose doctrine, saying this is a common law doctrine that says if the primary purpose of your meeting is not able to be fulfilled because of unforeseen events beyond your control, then you can walk away from the contract without liability. It's not something in the contract itself. It's this kind of extra contractual common law doctrine, but it's real. There's a lot of case law on it, but one of the things the case law suggests is that the purpose, if you want to rely on this, the purpose has to be stated in the contract itself. So just prophylactically, it's a good idea to do that. And then finally, despite the fact that you're no longer probably ever going to be able to get event cancellation insurance that covers coronavirus-related claims, you still can get coverage for other communicable disease-related claims, particularly in the Showstoppers and Expo Plus. If you buy the endorsement, it just won't cover coronavirus. Again, all of this stuff is subject to change, and who knows how the insurance carriers are going to modify this stuff going forward. But there's also a lot of other unforeseen events for which I think a lot of folks are realizing the importance of event cancellation insurance and that it's generally worth the cost. Again, assuming the cost remains reasonable, which it typically has been in the past. And then compare and contrast. So negotiate, for endorsements to try to, redefine definitions and exclusions, and then compare and contrast. None of these policies are the same. I mean, Showstoppers and Expo Plus tend to be the same, but what they're willing to do in terms of endorsements or whatnot are going to vary from one to the other. And I came across for the first time a new event cancellation carrier policy I had not seen before. It's the same underwriter as one of them, the Lloyd's of London, but it's a completely different policy form and written in a very different way, and there was no communicable disease exclusion. So compare and contrast, work with a good insurance broker who knows all of the various options out there, and play them off against each other, evaluate which one makes the most sense for your association. So with that, we are going to open it up for questions, and let me open up the question box here and see what we have going. Okay, just try to make this a little bit bigger. Okay. All right, we have 150-person meeting scheduled at the end of May in San Diego. The sales contract is telling us that we cannot invoke force majeure because it's too soon. If we wait, our cancellation fees would go up by $50,000 if force majeure is challenged. What happens if we invoke force majeure for a meeting after the current government restrictions are scheduled to expire? The question goes on, but I'm not going to go through all of that. But look, in short, this is exactly the kind of stuff I'm talking about. Yes, if the period of the governmental ban does not extend until May in San Diego, and I don't remember offhand, I have to consult our cheat sheet, then you're right. It is too soon to invoke it, and I would not invoke it yet. Now, are you risking, and I've heard this from a number of clients, how these cancellation penalties go up as you get closer to the meeting. And a lot of my clients have said, yeah, we have this, on Friday, it's going to be this triggering date that our fees are going to go up by X amount if we don't cancel. Shouldn't we cancel now to minimize the downside risk? It's a little bit of a game of chicken, and it's a game of, I don't know how many of you are, poker players or whatnot, but, there is some of that involved here in trying to figure out, what's going to give me the best odds? What do we think is going to happen? Do we think it's likely that whatever governmental ban exists, through the end of April is going to be extended through the end of May, or not? Obviously, I have to look at how your language in the force majeure clause is written. It looks like from this questioner, you have the impossible or illegal standard, not the more flexible impractical. If you have the impractical language in there, then the governmental ban is much less important. It's still relevant, but it's much less important, because then even things like the federal government's advisories and whatnot become relevant to what's impractical. If you remember when I was talking about all that stuff, I said that whole discussion was really about the clauses where it's impossible or illegal to hold the event. If you have the more favorable language, then you're going to be in much better shape. Can you talk about business interruption insurance and how it could potentially relate to coronavirus. Yeah, unfortunately, that's not an issue in the past that I had historically taken the time to learn a lot about. It's something that I am going to need to, but at the moment, I don't have enough knowledge about business interruption insurance to be able to speak intelligently to that. But if you guys are interested in hearing more about that, let me know. I'm happy to connect you with some insurance brokers, although they are unbelievably underwater at the moment. But I will have more information about that. And as I was talking to the CES staff, I will likely be doing future webinars on other legal topics that are critical as a result of this crisis and the impact it's going to have on associations, and that will almost certainly be one of them. If a contract is entered into with a venue after a force majeure event began, and then the force majeure event gets worse, making it illegal or impractical. So this is an interesting question. With insurance, event like liability insurance and event cancellation insurance specifically, it's all about unforeseen events, and you generally cannot get coverage for foreseen events that we know are coming. With a contract and with force majeure, it's not necessarily about what's foreseen, what's able to be foreseen or not. It doesn't necessarily have anything to do with that. Now, but it all depends on how it's written. If that first part of the test refers only to, Exegod and A, B, C, D, E, F, all these certain things, or other unforeseen events beyond the control of the parties, and you've signed that contract after the this virus was already, everyone is well aware of it. If I'm the hotel, I'm going to take the position that sorry, but this is not an unforeseen event. This was foreseen at the time that we signed it. Granted, if you had signed this contract 6 months ago, a whole different ballgame. So that's why, and it's a very important point, I should have mentioned this earlier, when we are now working with some associations on rescheduling their events and working on new contracts and new force majeure provisions, it's really important that you make sure that that language is in there. So it just says Exegod, fires, strikes, disasters, disease, or other things beyond the control of the parties. So certainly, this is beyond the control of the parties, but you want to make sure it doesn't talk about unforeseen circumstances or anything like that. I don't know if that was the exact question, but that's a really important point to make. And I should say for all of you, if I'm not going to be able to answer all your questions, feel free to follow up with me separately. My contact information is here on this final slide. Sorry, let me make this bigger. And I'm hoping my reading the questions is not showing up on your screen. Would that locking in the conditions at the time, I think that means the time of the cancellation, stand up in court from the hotel's perspective, or would the court say it's reasonable to assume you can't perform your meeting planning and get attendees together in the next 2 to 3 months? This is a really important point for two reasons. First off, the hotels are definitely taking the position that the facts are locked in at the moment they get the cancellation notice. There's no question about that. We've heard that many, many times, and this is coming clearly from kind of corporate legal, the big chains. That's the position they are taking. And we've had literally several where the cancellation notice was provided, and a day or 2 days or 3 days later, a governmental ban came down, which prohibited their meeting, which was going to begin, say 3 or 4 days later, and literally would have prohibited their meeting from occurring even if they had not issued the cancellation notice. I don't know how this is going to play out, but my position has been, as an advocate for the associations, that look, it doesn't matter. I mean, of course it matters what facts exist on the ground at the moment you give the cancellation notice, and I'm going to advise every client always to try to get those facts as favorable. That being said, if the meeting would not have legally been able to occur anyway, is it fair for, and there are, principles in contract law and kind of extra contract law, like outside of pure contract law, about unjustness and whatnot. Would it be just to allow the hotel to collect the full amount of cancellation penalties when they would not have been able to hold the meeting in the first place? So forget about the technical application of force majeure. This really goes to the calculation of damages. And so say yes, we didn't have a valid force majeure argument because it was impossible or illegal, and it truly wasn't illegal or impossible. So we concede that. But when you calculate the damages, how can you let the hotel collect full damages when literally the state or the city would have prohibited from having the meeting in the first place? It's an argument. I don't know how it's going to play out in some of these cases, but it's something to keep in mind. And then the other question is, how far out? So say you have a ban, we're dealing with this a lot right now. So I'll give you that example back to DC. Forget about the hotel, this potential hotel exception, which is a nightmare. But let's say DC, the ban right now goes through March 31st. Conference is scheduled for mid-April. We know the state of the crisis right now. Almost anyone in the country, if you ask them, would say, of course, the DC mayor is going to extend the ban, into next month, at least till the end of the month, maybe longer, maybe indefinite. Would it be reasonable and appropriate for the association, even though the ban doesn't technically extend into next month yet, to say, look, we can't wait that long. We're already 3 weeks out from our meeting. We're going to be 2 weeks out next week. We can't wait any longer. It's not reasonable for us to have to wait until the ninth hour. People make plans. We're incurring expenses, everything else. I agree with that. And what my basic rule of thumb has been, and this is just from my gut about seeing these things, is once you get to a month out, even if the ban doesn't technically apply, I keep saying to clients, if you can wait until the ban technically unambiguously applies, you're in a better position. But if you can't wait any longer, I think it's a strong argument, particularly right now at this state of the crisis, only going to get worse before it gets better. I think that I think that once you're a month out, you're going to have a pretty strong position. And I think obviously we don't want to have to litigate these things, but if we did, I think most judges would be really hard pressed to say that that was an unreasonable or irrational decision to make. Do hotels, let me take just a few more questions and we got to stop. And I said, you guys can follow up directly with me. Do hotels have a right to keep deposits above the amounts we owe per the contract? No, of course not. Legally, first off, there is this concept of offsets that if you made a deposit, even if the contract doesn't specifically say they can keep the deposit to pay for cancellation penalties, if you lawfully owe them the cancellation penalties, they are going to be able to keep the deposit. Now, if the cancellation penalties, go up to say $300,000 and they have $350,000 of yours as a deposit, then legally, no, they cannot keep the other 50. They should have to return that to you. But my point here was more possession is 9/10 of the law. Let's look at who has the money for purposes of negotiating leverage and strategic decisions. When polling attendees about potential attendance, should the reason for not attending be asked as well? Absolutely. In fact, that's my whole point. Polling your attendees whether they're planning to attend, that doesn't do you any good, frankly. I mean, it might have other value, like as we get closer to the fall or whatnot, if things start to clear up a bit, that could have some real value in just determining whether to hold the meeting at all or how far to reduce your attrition minimums and guarantees and stuff like that. But for right now, the only reason I think the polling is relevant is to find out, are they subject to some sort of employer or institutional based travel ban? That's frankly the only real reason for asking. And so yes, you absolutely have to ask that question. Do you recommend that local and state declarations and admonitions be used when citing the impact on your business, or dismissed for the reasons you stated, not as a legal basis for cancellation? I mean, first off, I'm an attorney, so I'm focused on the legal aspects. And a lot of these declarations and admonitions are having an unbelievably tremendous adverse impact on different businesses and industries and whatnot here in DC and everywhere else. That aside, I'm focused right now just on the cancellation notices. And as I said earlier, you absolutely want to focus first and foremost on any bans, and right now it's not federal, so it's just state and city and county wide, that directly apply to your situation without question. But then you also, and at least what I believe and what we've been doing, is throwing in all of the other admonitions and recommendations, even like a ban from a neighboring city, or reduced. Now we're seeing significant reductions in air travel, and we could even see a complete or virtually complete shutdown, including from certain cities. These things are other things that will make it impossible to hold a meeting. And so as these things develop, We actually haven't seen it quite yet, but we're about at that point where I know my colleague and I are going to start to work those things into the rationale as well, because it's very relevant to whether it's impossible. And despite the fact that the hotel attorneys may be taking a position that it's not impossible or illegal unless there's a governmental ban, that is just simply not the case. And in fact, many of these force majeure provisions say that if there's a curtailment of transportation that, like public transportation, like airlines, that prevents 25% or more of your attendees from making it there, that in and itself is a qualifying force majeure provision. And so you want to look carefully at that language. Are any insurance carriers writing event cancellation insurance with communicable disease coverage now? They're not writing it with coverage for coronavirus related claims, but as far as I know, and I'll have to, I've yet to go through the process with a client of securing new event cancellation insurance for a new meeting that's being scheduled or that has been scheduled, but like securing new coverage. I don't know for absolute certain if that, for instance, the communicable disease endorsement from Showstoppers and Expo Plus policies is still able to be purchased in the same form, simply with an exclusion for coronavirus. The last I heard it was, I've never seen it firsthand though, so I can't tell you for sure, but I believe that's the case. And frankly, if that's available, you ought to purchase it, because, you know, God forbid we could have another virus in 2 years that's not coronavirus related, but that is something else. Again, it also depends on how the carriers are defining coronavirus. As you know, COVID-19 is kind of one particular virus that derives from coronavirus, and I am not an epidemiologist or infectious disease expert or medical expert in any way. But regardless, it all depends on how they define it. Even the basic communicable disease exclusion that's in the core Showstoppers and Expo Plus policies is fairly specific and broad. But I had a client last week who was arguing, or trying to make the case to me that the technical way it's written, that perhaps it didn't apply at that moment in time. If we bound next year's insurance, so yeah, a lot of associations will bind their coverage for multiple years. And if you did that, you're one of the lucky ones. I mean, I think I saw one from a client yesterday. It was 4 years worth. You kind of lock in the better rates and whatnot. And so yeah, if you bound one and it covers your conferences for the next 2 years, and you bound it last year, so there was no COVID-19 exclusion, then yes, pending all the other stuff I said, they cannot go back and then institute a COVID-19 specific exclusion for that. All right, I'm going to do one more, and then I'm going to have to call this quits. I have a 3:30 client call Eastern. We have verbal confirmation of cancellation of our March board meeting that was to be held at our conference hotel. What confirming documentation should we be asking for? We have a contract for the same hotel for our annual conference in October. Yeah, this is a good point. I had a couple clients that got verbal notice from the hotel that they were going to accept, you know, force majeure cancellation. One where the hotel said verbally, we're going to cancel your meeting, and another one where the hotel said verbally, we're going to accept a force majeure cancellation. In both cases, we followed up, our client did, and we drafted, you know, some written confirmation of the same. It's very important if you want to get written confirmation from them. So for instance, if they're canceling a March board meeting, and it doesn't look like you were having it was the same conference hotel, but you weren't having a conference at the same time. So if they cancel the March board meeting, obviously you write back, and we're in writing confirm what you told so-and-so on so-and-so date that the meeting is canceled. You know, we thank you for your cooperation in confirming that there'll be no cancellation penalties, etc. And it says we have a contract with the same hotel for your annual conference in October. I don't see that transaction, that instance of cancellation, really having any bearing on the October meeting at all. I mean, obviously you have hopefully a good relationship with the hotel and whatnot, but I don't see one having any direct tie to the other. With that, I'm going to wrap it up. Feel free to reach out to me with other questions that you might have. Thank you to Sarah and Seth for a great job in organizing this, and appreciate you guys listening all the way through. And if I can be of any help answering any questions, please let me know. Thank you very much.